So today we'll be dealing with the major provisions of Companies Amendment Act 2017 for CA final, corporate and economic laws paper. This amendments is applicable from May 2019 exams. So you must be very careful about the nitty-gritties of the amendments brought in by Companies Amendment Act 2017. It has been notified under different notifications. So each video we will try to cover the major parts of the amendments. Today we'll be dealing with the amendment in the KMP. We'll be dealing with the amendment in the KMP, key managerial personnel. The amendment in KMP is not in the provisions, that is, there is no amendment in 203. The applicable provisions of KMP is definition 251 and provision in 203. So the amendment is in the definition part, that is 251, wherein you all know that the definition of a KMP, it starts like this. KMP of a company means and includes, one category is MD, CEO, manager, then whole-time director, then you have company secretary, then you have CFO, then you have such other persons as may be prescribed. Now a new clause has been introduced in 251. The clause number is 5. Clause number 5 has been introduced. Clause number 5 has been introduced. A new clause has been introduced via Companies Amendment Act 2017 in 251, the definition clause. The definition clause, the new clause speaks about, say, new category of team where they had introduced the concept of not more than one level of the directors. Not more than one level of directors. So MD is there, already the KMP is there. Now they had introduced new category called one level below the director board. Any officer can be designated as a KMP. The conditions are: 1, they should be not more than one level below. One level below. That's the first condition. The officer or the person to whom you are going to designate is just one level below the director board and not more than one level below the director board. Condition 2 is they should be designated as a KMP. They should be designated as a KMP. For example, if you are going to designate a vice president or the chief strategy officer or the chief knowledge officer or the chief information officer like the IT companies use, or chief technology officer, if you want to designate them as a KMP, they should not be more than one level below the director board. Second condition is they should be designated as a KMP. And the third condition is they should be in the whole-time employment, WT. They should be in the whole-time employment. So if the company can satisfy these three conditions, they can designate any officer not more than one level below the director board as KMP hereafter. So I will repeat the three conditions which you have to keep in mind. 1, they should not be more than one level below the director board. 2, they should be designated as a KMP, as a board resolution, as you know. And third one, they should be in the whole-time employment of the company. If three conditions are satisfied with effect from Companies Amendment 2017, you can designate any officers as a KMP apart from company secretary, apart from CFO, apart from MD, apart from CEO, apart from manager. So this is the logic behind the introduction of the new amendment. As I told earlier, KMP amendment is this much only because there is no amendment in the parent provisions, is section 203. So this is a good area for asking a practical question, that they may ask a question that A Limited has passed a board resolution designating the chief marketing officer, CMO, as the KMP, whether the decision of the board is right. You can write the answer like that. This has been introduced in the amendment in the definition to clause 51, while inserting a new clause called 5, in which if the three conditions are satisfied, we can appoint the chief marketing officer also as the KMP. So this is